two people apply for the same patent? Simple question. I think it could be taken at least two different ways.
Yep.
The first way I read this was you got co-inventors of the same invention. Can you both apply for it? I think the easiest way I should say is to have you both listed as inventors and use the same attorney. And that way you're all sort of together. In a lot of cases, the best way to do that eventually will be to assign your rights to a company. If you're in business together, you're planning to move it to market, you can both individually assign it to an entity, and that way it's governed and controlled by a business. Maybe if the question is being asked, can two people independently invent the same thing and apply for the same invention? The answer is yes. And who gets the patent? The one that files first. So it's all about that all-important filing date. And that's why there is a bit of a race, a lot of urgency to get patent applications filed as soon as you're able to get it to the point where it's an invention. And that's one thing that I know Troy, myself, when I do consultations, I sit down and help inventors appreciate, have you gone from that idea conception phase to an invention? Does it have enough meat on the bone? Have you been able to explain the invention so much that you could tell someone in your industry that much detail so they could make it and build it and use it? That's now at the level where you can actually file. And we recommend doing so as soon as possible. We do actually put one little hurdle in between. We say we should do a search. So a really thorough patentability search, especially if it's something outside of your industry, something you haven't done day in, day out. After doing that search, we want to get you filed right away. Matt, any thoughts on this, or maybe different ways the question could be asked?
Yeah, I guess from a trademark standpoint, you can have co-owners of a trademark application at the USPTO. I'm dealing with that right now. We represent a company that has a co-owned trademark with another individual. Nobody knows how that happened, right? Because the original attorney's gone. The attorney, the other party has no clue, right? Which is just complete hearsay at this point, based on, we own it for this and you own it for that, and just a mess. So I always try to steer clear of dual-owned trademark applications, because it's just inevitably going to be a problem. So you can, but you shouldn't.